39 years on the bench. I want to tell you what those years produce. Not wisdom, not perspective, not the things people say when they are being generous about a long career. What 39 years produce is a specific sensitivity to weight. You learn to feel the difference between a case that is heavy and a case that is heavy in a way that does not leave the room when the proceedings close. This one did not leave the room. It came with me. I am dedicating this episode to every child who has ever been the adult in the room before they were old enough to be. Before I tell you what happened in that intake court on a Tuesday morning, before I tell you what I saw, what I asked, and what I said from that bench when I had heard enough, I need you to understand what was on the other side of the door when I walked in. Not in the file, on the other side of the actual door. My name is Marcus Reed. I spent 28 years as a circuit court judge in Fulton County, Georgia. I have seen a great many things from that seat. Raw courtroom exists because some of those things deserve to be said out loud, without the ceremony the robe required, to people who are prepared to hear them. If that is what you came here for, subscribe, hit the bell, stay with me. And when this episode is over, I want you to tell me in the comments, what is the hardest thing you have ever watched a child carry alone? Not a story, just what it was. Put it on the record. Prepare yourself for what comes next, not because it is difficult to hear, because it is exactly, precisely true. There are cases I closed and drove home from, and there are cases that rode home with me. This one rode home with me, not because it was the most complicated proceeding I presided over in 28 years on the bench. It wasn't. The file was thin. The charge was straightforward. The courtroom was a juvenile intake room in a county building that smelled like floor wax and bad coffee, and the docket that morning had 4 cases ahead of it. By any external measure, this was a Tuesday. But I have learned, and it took me longer to learn this than I would like to admit, that the weight of a case has nothing to do with the thickness of the file. Some of the most consequential things I ever said from behind a bench were said in rooms exactly like that one. Small rooms, fluorescent light, plastic chairs, the kind of room where people go when they have no other room to go to. I want to tell you what I saw when I walked in that morning, not what the file said, what I saw. There was a boy in the chair reserved for the respondent, 14 years old, which I already knew from the file. But knowing a number and seeing a face are 2 different things. He was wearing a school sweatshirt, the kind with a zipper, the kind that 14-year-olds wear because it is the garment available, not because anyone selected it for this occasion. He was sitting the way people sit when they do not have attorneys who have told them how to sit. Not slumped, not defiant, just present, the way someone is present when they have run out of the energy required to perform anything other than presence. I noticed his hands. They were on the table in front of him, flat, still. The hands of someone who has been awake for a long time and has stopped pretending otherwise. And then I looked to my left through the narrow window of reinforced glass set into the door of the intake room, and I saw a girl in the hallway, 8 years old, maybe 9. She was sitting on the wooden bench that lines that corridor, the bench that is there for people who are waiting to be called in, the bench that most adults find uncomfortable after 10 minutes. She was sitting with her hands in her lap, folded, the way children sit when a grown person has told them to sit still, and they are determined to do exactly that. She was waiting for him. I understood something in that moment, before I had read a word of testimony, before the defensor public had opened his thin folder, before anyone in that room had spoken a sentence on the record. I understood that whatever I was about to do in the next hour was going to be felt by a girl sitting on a bench in a hallway, a girl who had not been charged with anything, who had not been summoned by this court, who had simply come because he had come, and she did not know how to be somewhere that he was not. That knowledge did not leave me for a single moment of the proceedings that followed. The charges filed were straightforward: unlawful employment of a minor, night shift labor in violation of the applicable statutes governing working hours for individuals under the age of 16. The establishment had been cited. The minor had been taken into temporary custody pending a juvenile intake hearing. Standard procedure, the kind of thing that goes through a docket on a Tuesday without anyone raising their voice. What was not in the standard procedure language was this: the complaint had been filed not by a labor inspector conducting a routine audit, but by another business in the area. Someone had seen this boy, had seen him specifically, carrying inventory, moving boxes, sometime between 2 and 4 in the morning, and had made a phone call, not to ask why he was there, not to ask if he needed anything, a phone call to the labor enforcement line. I have been a prosecutor. I understand why that line exists. I understand the purpose it serves. But I held that detail for a moment before I let it pass. Someone saw a child working in the middle of the night, and their first and only response was regulatory. I want you to hold that detail too. The defensor public, a man I had seen in that room perhaps 30 times over the years, a competent attorney doing an underfunded job with professional consistency, had a strategy that I recognized the moment he opened his folder: acknowledge the violation, present mitigating circumstances, request diversion rather than formal adjudication. It was the correct strategy for the case as filed. It was the strategy of someone who expected to be out of that room in 45 minutes. I asked him to pause. I asked the representative from Protective Services, a woman who had arrived with a separate folder, a thicker one, the folder that dealt not with the charge but with the background, to remain at the table. And I asked for that folder before the defensor public had finished his opening. What was in that folder is not complicated to describe. A father who had left a household approximately 22 months prior, current whereabouts not reliably established. A mother listed as temporarily unable to exercise parental custody, which is the careful language those documents use when the reality is that she was not there, had not been there in a consistent way for a period measured in months, and that what had existed in her absence was not chaos, not neglect in the way the word is commonly understood, but something more specific and more difficult. 2 children managing the logistics of their own survival with a competence that no child should need to develop. The boy had been working at that establishment for approximately 4 months. 4 months of night shifts. He had arranged the schedule so that he could still attend school. He had arranged the income so that the rent on the single room where the 2 of them were living was covered. He had arranged for his sister to have food, which she did consistently for 4 months without interruption. I want to be precise about what that means. He had not stumbled into a temporary solution. He had built a system. A 14-year-old had assessed his circumstances, identified the constraints, found a workable response, and maintained it, alone, for 4 months. There's a word for that. I will use it later. But I want you to hold it here without the word for a moment, because the word is less important than the fact. The defensive public was ready to present the mitigation. I asked him to hold it. I had a different question, and I wanted to ask it directly. I addressed the boy. I asked him, on the record, in my courtroom, in the way I have asked questions from that bench for 28 years, to tell me about his sister. He did not hesitate. That was the first thing I noted. I have watched people under pressure in that chair for nearly 3 decades. There is always a calculation before an answer, even when the answer is the truth. There was none here. He told me her name. He told me her age. He told me what she ate for breakfast and that she had a school bag with a broken zipper that he had been meaning to replace. He told me that she slept on the side of the room closer to the wall because she felt safer there, and that he made sure the lock on the door was the kind that locked from the inside so she could lock it when he was at work. He told me this not as a prepared statement, not as mitigation strategy. He told me this the way you tell someone about a person you are responsible for. The way you enumerate the details of a life you have organized yourself around protecting, because those details are what protection consists of. It is not abstract. It is a broken zipper on a school bag. It is which side of the room is closer to the wall. I have presided over a great many proceedings in which I was told about a defendant's family circumstances. I know the shape of that testimony. I know what it sounds like when it is constructed, when it is offered as currency, when it is calibrated for the room. This was not that. This was a boy telling me the facts of a situation he did not regard as remarkable, because it was simply the situation, and he had simply responded to it, and the response had required night shifts because night shifts paid more, and that was the arithmetic, and here he was. I asked him one more question. I asked him whether he had told anyone, a teacher, a neighbor, a relative, any adult in his proximity, what was happening at home. He looked at me with an expression I have been trying to find the exact words for ever since. It was not defiant. It was not ashamed. It was the expression of someone for whom the question had simply not computed as a real option, as if I had asked him whether he had considered flying. He said quietly, "Who would I tell?" 2 words. 3 syllables. And I want to tell you that in 39 years of this work, across thousands of proceedings, there are moments that stay with you not because of what was said, but because of the specific weight of what was not said inside them. Who would I tell contains in those 3 syllables the entire structure of what had failed this child before he ever appeared in my courtroom. It contains the absence of every adult who should have been present. It contains the months of silence. It contains the decision made alone that the only available answer was to work. I took a breath, the measured kind, the kind I have had to learn over a very long time on a bench where taking an unmeasured breath has consequences. Then I suspended the proceedings, not closed them, suspended them. I asked the Protective Services representative to step forward. I asked her, on the record, in specific terms, what the current status of active monitoring for this family was. The answer, also on the record, was that the case had been flagged for review 9 months prior following a welfare check, and that the review had been scheduled and rescheduled and had not yet occurred. 9 months. The case had been flagged for review 9 months ago. The review had not occurred. The boy had been working nights for 4 months. I want to say something about that gap. Not as commentary on the protective services system in the abstract. I am not going to do that, because that is not what happened in that room. What happened in that room is that I had a document in front of me that showed a 9-month gap between the identification of a problem and any actual response to it. And I had a boy in front of me who had, in the absence of that response, responded himself with night shifts, with a broken zipper he was planning to fix, with a lock that worked from the inside. The system had a 9-month gap. He did not allow a 9-month gap. He closed it with his own labor, which was illegal because he was 14, and the law that makes it illegal exists to protect children, and the protection that law was designed to ensure had not arrived. That is the full picture. I want you to hold the full picture. I asked the officer to bring the girl in from the hallway. She came in quietly. She found him immediately. She did not look around the room. She looked directly to where he was sitting, and something in her posture changed in a way that I recognized because I am a parent, and I know what it looks like when a child locates the person they feel safest with. She sat next to him. He put his hand briefly on her shoulder and then returned it to the table. The Defensor Public had stopped preparing his mitigation. I looked at the charge in front of me, unlawful employment of a minor, and I thought about the word unlawful. I have spent my career with that word. I know its precision, and I know its limits. Unlawful describes a relationship between an act and a statute. It does not describe the relationship between an act and a human situation. Those are two different conversations, and this court was capable of having both of them. I archived the charge, not suspended it, archived it, under the following conditions: that protective services would open an active case file, not a pending review, an active case file, within 72 hours, that the housing situation would be assessed and stabilized, that appropriate support would be arranged, not for the boy, for the situation that had produced the boy's necessity. The charge against him was not the problem. The charge against him was the symptom of a problem that had been sitting in a folder marked pending review for 9 months. Then I said something I want to tell you carefully, because I chose the words with care, and I want them to land the way I intended them. I told him directly that what he had done, the working, the organizing, the protecting, the lock on the door and the school bag and the side of the room closer to the wall, was not something this court was going to characterize as a failure. That the failure in this case had a different address. That he had done under impossible circumstances what a decent person does, and that a court that existed to protect children was not going to be the place where he was punished for having protected one. He looked at me. He did not say anything. His sister was looking at me too, 8 years old, 9 years old, with her hands still folded in her lap, and the same quality of attention in her face that I had seen in his, the attention of someone who has learned to watch very carefully because the consequences of missing something are real. I thought about my father, a man who drove a mail route for 31 years and understood, in the specific way that people who work with their hands and their time understand, that the system produces different results depending on where you are standing relative to it. He raised me with two things held simultaneously: that the law was the most powerful tool available to ordinary people, and that it was also the most commonly used tool against them. He held those two things without contradiction. I built a career trying to make the first one true more often than the second. In that room, on that Tuesday morning, with a girl's hands folded in her lap and a boy's hands flat and still on a table, I had the authority to determine which of those two things was going to be true for these two children in this proceeding. That authority is not abstract. It is not a principle. It is a decision made in a specific room at a specific moment, and it belongs entirely to the person sitting in the chair with the authority to make it. I made it. What I want to leave you with is not complicated. It is, in fact, as simple as anything I have ever said in 39 years of this work. There was a child in that room who had been left without protection, and who had, in the absence of that protection, built his own. He had built it carefully, maintained it consistently, and sustained it for 4 months without being asked to, without being thanked for it, without anyone in the official structure that was supposed to protect him noticing that he was carrying something no 14-year-old should carry. The court existed to protect children. There was a child in front of me. I protected him. I protected both of them. That is not a complicated sentence. But I have learned, and I have learned it the hard way, in cases where the simple sentence was not delivered, in proceedings where the weight of process crowded out the weight of the person in the chair, that the simple sentence is the hardest one to say. Because saying it clearly, without the procedural language that makes everything sound equidistant from the truth, requires you to be willing to say out loud what everyone in the room already knows. Everyone in that room knew what this case was. It was a boy who loved his sister. It was a system that had not shown up. It was a bench that had the authority to say both of those things out loud and act on the second one. I said them. I acted on it. And that girl with her hands in her lap, I want you to know this. When I archived the charge and the proceedings were formally closed, she looked at her brother, and then she looked at me. And there was something in that look that I recognized from the deepest part of this work. The look of a child who has just discovered that a room full of adults was on this occasion arranged on her behalf. She deserved that look. She had deserved it for a long time before I was the person who could give it to her. I have one question for you, and I want you to answer it in the comments because I read every one. Think of someone, a child, a young person, anyone in your life who grew up faster than they should have because the adults who were supposed to show up did not show up. Someone who built something with their own hands because no one built it for them. I am not asking you to explain the whole story. I am asking you to write their name, just the name, because they were in that room before I ever was, and they deserve to be named somewhere. If what you heard today felt like something you have been waiting to hear someone say out loud, I would be glad to have you here. Subscribe. Hit the bell. What I bring to this channel is the same thing I brought to that bench for 39 years. What I saw, said directly, without the ceremony that used to be required of me and no longer is. These two children have the same last name. He carried it as if it were the whole of his responsibility. On that Tuesday morning, in that small room with the fluorescent light and the plastic chairs, I made sure the record carried it too.